Namaskar everyone. I am Trupti Panigrahi, Assistant Lecturer, OP Jindal Global University, and I extend.
Just check whether we are already live streaming. Maybe he can tell us.
Yes, sir. Vishnu, sir, have we started?
We are live, ma'am.
Namaskar. I am Trupti Panigrahi, Assistant Lecturer, OP Jindal Global University, and I extend a very warm welcome to everyone present on behalf of Jindal Global Law School for this public lecture on interpretation of statutes, understanding judicial considerations. I will be moderating the lecture today, and it is an honor for us that Honorable Justice Arijit Pasayat has agreed to deliver this lecture for us. I would humbly request now our Honorable Vice Chancellor, Professor Dr. C. Rajkumar, to welcome our guest speaker today.
Thank you very much, Trupti. It is such a pleasure for us to welcome Honorable Mr. Justice Arijit Pasayat. We've all been inspired by his work for very many years, and it has been our very distinctive privilege to have him virtually deliver this lecture, although I must confess that we can't wait to bring him to campus when things become better, and I would like him to come and interact with our students and faculty. Thank you very much, sir, for accepting our invitation to deliver a very important public lecture on interpretation of statutes, understanding judicial considerations. The theme of today's lecture is absolutely at the core of the role of judiciary in any democracy. In fact, historically, there have been a number of principles that have been evolved when it comes to adjudication, and the contestations among the different principles of interpretations has been the part of the evolution of jurisprudence in different jurisdictions. If you look at the United States, for example, the US Supreme Court is to a large extent divided by the kind of interpretive principles that individual judges adopt, which will ultimately lead to the kind of jurisprudential outcomes than interpretations that will be adopted by judges themselves. Of course, I think in our own jurisprudence, in our own functioning of our own Supreme Court, but also other courts, our judges tend to have adopted a more, let's say, broader and a very progressive approach at different points of time and dealing with different cases. They have not adopted a one-size-fits-all judicial interpretation, and that has actually enabled individual judges to adopt different methodologies and approaches to judicial interpretation, not so much on the basis of their personal ideologies, but more on the substance of the matters that they are dealing with, including the type of facts and circumstances at times, but most importantly, the kind of issues that they're responding to. The evolution of law by our courts have not necessarily been entirely dependent upon the individual ideologies of our judges, and I see that as a positive trend that has developed jurisprudence in India. I also want to mention that interpretation of statutes is one such area which unfortunately receives very little attention in the law schools itself, largely because of the fact that most of our distinguished judges may not necessarily engage significantly with law students. Justice Pasayat has taken lecture, but equally important that law schools have not given adequate importance for developing this thinking among our law students, because after all, bright law students, law graduates, ultimately, some of them will end up bring this framework of understanding the importance of interpretation of statutes at the level of law school education itself. The heart of legal thinking, legal analysis, as well as jurisprudential analysis is actually about interpretation. Before I welcome Honorable Justice, I want to introduce Justice Pasayat, all of the audience here, although it is customary to mention that he does not need any introduction, but it is true he has been a very towering figure, but I want to quickly introduce him. Justice Pasayat is besides known for his fearlessness and independence towards adjudication, he has had a very outstanding legal and judicial career. He was an additional judge in the High Court. He then went on to become the Chief Justice of the High Court of Kerala in 1999. In the year 2000, he was appointed as the Chief Justice of the High Court of Delhi, judge of the Supreme Court of India. He delivered numerous significant judgments of India concerning the findings of the Mandal Commission. He's also served chairman of the Supreme Court's National Legal Services and the vice chairman of the Special Committee on streamlining black money. Now, I must confess that this work that he did in the National Legal Services Authority has a large-scale implication on promoting issues relating to legal aid across the country. And in many ways, he galvanized consciousness among a number of members of the legal profession and the legal education community to recognize the importance of legal services. From streamlining the functioning of Lok Adalats to giving a directive on banning ragging in colleges, from ordering for compulsory registration for marriages to maintaining the political parties that should not use colleges and universities for political purposes, he has reflected through his rulings his he has taken task to people injustices in the system. I also remember very well that Dr. R.K. Raghavan, former director CBI and somebody who was working closely with Justice Pasayat on that ragging committee, mentioned to me how keenly Justice Pasayat would go into details of these matters so that ultimately, they don't, these things don't become lofty ideals to pursue, but they are able to have a change in the ground itself. So I'm very, very delighted once again to have Justice Pasayat deliver this virtual public lecture. I don't want to take any further time, so let's move with the program. Thank you once again, sir, for being with us. And I'm very happy that you're delivering this lecture today because we've just been ranked by the QS World University Rankings as India's #1 law school, and we have ranked 76 in the world. And it augurs well that we begin the first academic program after this recognition. Very much.
Thank you so much, Professor Raj. It is personally actually an honor for me to be moderating this lecture in your presence and to have Justice Pasayat with us today. So I would now like to invite Professor Srijit, our Executive Dean, to deliver the introductory address.
Good evening, Justice Pasayat, Vice Chancellor Professor C. Rajkumar, Ms. Tripti Panigrahi, and everyone connected to us through YouTube. It's a great honor to give the introductory remarks for this distinguished public lecture, Interpretation of Statutes, Understanding Judicial Considerations. The theological art of hermeneutics found its way into judicial reasoning through interpretation of statutes, as statutes became the textual medium to convey inputs for social ordering and reordering. As much as Paul Ricoeur and other linguists created a distinctive understanding of text, saving it from the sophistries of discourse, jurists developed a distinctive understanding of statutes, making law obtain social objective outcomes. Interpretation of statutes being a judicial matter, judicial mind becomes the medium for reading statutes. However, reading statutes is easier said than done, for a statute is a reflection of time-space, of history, of human social self-becoming, and of the potential collective willing and acting of social subjects. Hence, judges reading and applying the statute find themselves in a sea of meanings, possibilities, and potentialities. Every choice of meaning by judges creates a social reality for one, if not for many, if not for all. Hence, statutory interpretation demands extreme discipline in thinking from judges as they are surrounded by numerous considerations. For example, the phenomenology of the legislators. I would call it the phenomenology rather than the mind of the legislature, for the mind of the legislature would be too narrow a way to put things. Hence, the phenomenology of the legislators, the past, the present, and the future contexts of application the potential outcomes and impacts, and the normativity of reasoning they leave behind in the repository of judicial imagination. Justice Pasayat, former Judge of Supreme Court of India, will provide us a treat into such and similar considerations, and certainly much beyond them. It's a pleasure to welcome you, sir, and thank you, everyone.
Thank you so much, sir. In fact, I'd like to take this opportunity to tell the audience that it is because of Professor Srijit that we're all here today. When I proposed this lecture, I initially proposed to have this with only the section that I am teaching. But then Professor Srijit suggested that it should, the privilege of learning from Justice Pasayat should be available to everyone. And that's why we are here today. So without further ado, I would now request Honorable Justice Pasayat to begin with our lecture.
Sir, can you please unmute the most important line in the pandemic?
Okay. Okay. I hope all of you are safe. Rajkumar is looking smart. So I think pandemic hasn't affected him. Well, I can tell you something. First, let me congratulate you for the unique distinction that you have achieved. Well, I'll tell you a little background about it. When Tripti asked me to speak, I was baffled by this subject. Because normally for the last 1 year, when I have been asked to speak, I have been asked to speak about environment. People say that, sir, you are the green judge, you speak about environment. Sir, you speak about the difficulties that the courts are facing. For the first time, somebody asked me to speak on a dry subject like interpretation of statutes. And now I understand how and why you rank first. Because you take the most difficult subject to be deliberated, to be discussed, because we are all students. In fact, when I became a lawyer, I was told that a lawyer learns every day. He is a student every day. Every new case is a new chapter for him. So the law is developing so fast. But one particular facet of law which hasn't seen much changes is the interpretation of statutes. Because I'll tell you why. I will go a little back in history about why so much of importance has been given to interpretation. And the changes that we actually saw was because of law professors. The first important change in the interpretation concept was actually on the basis of something called interpretation and coherence in legal reasoning. So that legal reasoning, why that has become so important, I'll deal with it a little later. But legal reasoning has probably come into the area of discussion because of Ronald Dworkin. I'll come to Ronald Dworkin a little later. I will straight come to the subject of interpretation of statutes. It is a well-known proposition that legislatures are the lawmakers and the courts are only interpreters. This is at the heart of institutional essentialism. This basic segregation, which is a functional aspect, has been the foundation prompting development of a canon of statutory construction. One of the challenging concerns of statutory interpretation is to capture the ever elusive legislative intention. As both Professor Rajkumar and the Dean and the Professor told you, this is actually the elusive concept of interpretation of statute. For some, the intention is to be gleaned from the statutory language in the plain meaning rule, while statutory purpose is given primacy in the mischief rule. Thus, the legislative intention differs in both the rules, and therefore the need to find such intention remains a challenging task and is unquestioned. Under both the rules, the primary job of lawmaking is to be performed by the legislature, and courts make the final decision as to find the intention and declare the law. Merely 8 decades back, Justice Chakrabarti in Badshah versus Rajavalli, AIR 1946 Calcutta Full Bench, made a profound statement that we are advised that these contradictions can be understood if the factual context of the decision is kept in view. As a learned author had stated, the institutional essentialism has been subjected to ceaseless interrogation. Max Radin, a leading author in statutory interpretation, 43 Harvard Law Reviews 863, about century back had said that legislative intention fails to provide a stable anchor for interpretative exercise. Some others have said and demonstrated how courts pick and choose between canons to arrive at result-oriented decisions. This is what both Rajkumar and Professor had said, that you mold your decisions to suit the factual scenario. Some legendary authors like Bindra have essentially projected that courts are meant to carry out the will of the legislature, and therefore the unearthing of the legislative intention is an inevitable activity. The maximum lawmaking role that is considered to the courts is that they may smoothen the rock that the legislature has inadvertently left in the legislative fabric. But that they should undertake the supplementary activity guided by the legislative choice. Lord Denning had propounded this advice. There are others who hold the complementation of judicial process. According to them, judges are better suited than legislatures to unearth important principles beneath statutory language and waive unforeseen issues and disputes. Of late, courts in India, especially the Supreme Court, have given a restraint a go-by and have preferred more activist approaches. In Union of India versus Breeze Nandan Singh, 2005, 8 HCC 325, the Supreme Court observed that courts must avoid the danger of a priori determination of the meaning of a provision based on their preconceived notions of ideological structure or scheme into which the provision to be interpreted is somewhat fitted because they are not entitled to assert legislative function under the disguise of interpretation. A recent phenomena is dynamic statutory interpretation. As primacy is accorded to legislative will, fathoming of the originating intention extensively prompts the interpretive enterprise. For this purpose, mostly while interpreting the Constitution, assistance is obtained from extrinsic aids like constitutional assembly debates. There were more cases where judges gave dynamic interpretation to the constitutional text. This, however, posed problems, and the Supreme Court in the state of West Bengal versus Kishoram Industries 2004 10 SCC 201 brought out some of the inherent difficulties of dynamic interpretation. The judges differed in their assessment of the changed circumstances. The majority held that courts should read legislative entries in such manner that the resources raising capacities of the states stand enhanced. Consequentially, some of the bias of the original constitutional text in favor of the union's government should be reduced with interpretation. Interestingly, the dissenting judge opined that in the globalizing era, there was need for uniform economic policies, and any interpretation which reduces federal leeway should be avoided. In a criminal matter dealing with rape, the court was required to adopt a dynamic approach while interpreting the Indian Penal Code in Sakhi versus Union of India, 2004, 5 SCC 518. The Supreme Court held that a penal statute is required to give notice of unacceptable conduct so that people can mold their behavior to be in accord with law. The standard rule of interpretation is that penal statutes should be strictly construed. If a wrongful act does not come within the legal parameters, benefits of the omission should go to the accused. Interestingly, while dealing with anti-terrorist legislation, the Supreme Court preferred widest possible amplitude to the words should be given so that the challenges from terrorist and anti-national movements can be effectively met. See, Subhas Ramkumar Bind versus State of Maharashtra, 2003, 1 SCC 508. Balram Kumabat versus Union of India, 2003, 7 SCC 628. Prakash Kumar versus State of Gujarat, 2005, 2 SCC 409. It must always be borne in mind that interpretation is the method by which the true sense or the meaning of the word is understood. When Lord Goddard sees a remark that a court cannot add words to a statute or read words into it that are not there, he echoed what many judges had said in R versus Wimbledon, 1953, 1 QB 380. Between the grammatical meaning and the overall legal meaning, courts now draw a conceptual distinction. The two usually correspond, but sometimes there is a doubt. Here, concepts are useful. The question is always, does the grammatical meaning truly give effect to Parliament's imputed intention? If it doesn't, the legal meaning will be something else. In searching for the legal meaning of a doubtful enactment, the court now proceeds by identifying, determining, and weighing. It identifies the general interpretative criteria that are relevant to the facts of the particular case. It determines by reference to these criteria the specific factors that on the words of the enactment and facts of the case are decisive. It weighs the factors that go for and against each of the opposing constructions projected by the parties. About a century back, in Quebec Railway versus Vandry, AR 1920 PC 181, Lord Summer held that it will also be presumed that words in statutes are used precisely and exactly, not loosely or inexactly. The legislature is deemed not to waste its words or say anything in vain. The presumption is always against superfluity in a statute. An act should be construed as to avoid redundancy or surplusage. It is no doubt true. In a general rule, legislatures may be presumed not to make a superfluous provision. But this presumption is not a strong presumption, and it is not uncommon to find the legislator inserting superfluous provision under the influence of what may be abundant caution. It is well settled principle of construction that no part of the statute should be so construed as to convict the legislature of having engrafted statutory clause which would be of no purpose or avail to anyone. In short, a court should not be prompt to ascribe and should not, without necessity or sound reason, impute to the language of the statutory tautology of a superfluity. No word is superfluous, redundant, or surplus, as held by the Honorable Supreme Court in Indian Chamber of Commerce versus Commissioner of Income Tax, AR 1976, Supreme Court 348. A construction that makes any provision of a statute dead letter must be rejected. The court cannot supply a clear and obvious lacuna in a statute, but it is incumbent on it to avoid a construction which would render a part of the statute devoid of any meaning or application, as was held by the Honorable Supreme Court in the case of Shiv Bahadur Singh versus State of Andhra Pradesh, AR 1953, Supreme Court 294. Crawford in statutory construction says, quote, since no one may assume that legislature knew and understood the rules of grammar, such rules should be considered by the court in their efforts to ascertain the meaning of a statutory enactment on the theory that they will reveal or tend to reveal the correct sense for meaning thereof. There is one concept which is known as casus omissus. It means point or case unprovided for. When a given state of affairs does not come within the obvious meaning of the words of the statute, that is when certain contingencies are not provided for, or when the words do not embrace the particular question on hand, it is a case of casus omissus. In Commissioner of Income Tax versus National Tax Traders, AR 1980 Supreme Court 485, the Supreme Court held that a casus omissus should not be readily inferred. It is not the jurisdiction of the courts normally to enter into the arena of legislative prerogative of enacting laws as held by the Supreme Court in Ahmedabad Municipal Corporation versus Bhai, 1999, 8 SCC 139. In trying to solve a difficulty, courts should not proceed as mere grammarians of written law, but must search for the true intention of the legislature. That the intention of the legislature not to be judged by what is in its mind, but by its expression of that mind in the relevant statute itself. The only repository of legislature's intention is the language it has used. And in examining that language, it must be presumed that legislature knows the accepted vocabulary of legislative bodies and so knows what words are required and considered apt to effect a particular result. If it has not made a provision or used words from which a particular result can properly be found, courts will not be justified in finding it simply because a contrary decision would cause hardship to public. Therefore, not only will the courts prevent themselves from taking up the functions of the legislature, but the legislature may also profit because it may take care to avoid such deficiencies in future. The courts cannot venture upon the dangerous act of judicial legislation to supply omissions or remedy defects in matters committed to a committed, coordinated branch of the government. It is far better to wait for necessary corrections by those authorized to make them, or in fact, for them to remain unmade, however desirable they may be, than for judicial bodies to transcend the just limits of their constitutional power. This was observed in the Railroad Commission of India versus Grand Trunk, 1913, 179 IND 255. This was quoted by Sutherland in statutory construction. It is not permissible to create a casus omissus by interpretation, save in some cases of strong necessity. Two principles of construction, that is, relating to casus omissus and in regard to reading the statute as a whole, is well settled under the first principle. A casus omissus cannot be supplied by the court by judicial interpretative process, except in the case of clear necessity, when reason for it is found in the four corners of the statute itself. But at the same time, a casus omissus should not be readily inferred, and for that purpose, all parts of a statute or section must be construed together, and every clause of a section should be construed with reference to the context and other clauses thereof, so that the construction to be put on a particular provision makes it consistent enactment of the whole statute. In Ramesh Mehta versus Sanwal, 2004, 5 SCC 409, the Supreme Court observed that the court should not so interpret a statute as to create a casus omissus. This should be more so if literal construction of a particular clause leads to a manifestly absurd or anomalous result, which could not have been intended by legislature, as was observed by the Supreme Court in Padma Sundar Rao versus State of Tamil Nadu, 2002, 3 SCC 533. In State of Jharkhand versus Govind Singh, 2005, 10 SEC 437. Unique Butte versus UP Financial Corporation, 2003, 2 SEC 455. Union of India versus Rajiv Kumar, 2003, 6 SEC 516. The Supreme Court observed that causal summations cannot be supplied or created by interpretation, much less by wrong interpretation. One very important aspect about interpretation is what is the best mode to ascertain the meaning affixed to words or sentence by a deliberated body. The obscurity of any particular word may be removed by reference to associated words. The meaning of a term may be enlarged or restricted by reference to the object of the whole clause in which it is used. Clauses of the Constitution which involve a conflict of governmental powers must be considered with reference to the literal meaning of the words, their connection with other words, and general object to be accomplished. In a case of ambiguity, report of the drafting committee of the Constituent Assembly may be read as observed by the Supreme Court in A.K. Gopalan versus State of Madras, AR 1950, Supreme Court 27. It was further observed by the Honorable Court in UN Rao versus Indira Nehru Gandhi, AIR 1971, Supreme Court 1002, that the conventions prevalent at the time when the Constitution was framed, establishing a parliamentary system of government with a cabinet, may well be kept in mind while interpreting the Constitution. But if words of an article are clear, notwithstanding the relevant convention, effect will be given to the words. A constitutional provision will not be interpreted in the amplitude of a lexicographer with one eye on the provision and the other on the lexicon. It is the duty of the court to determine what particular meaning or particular sets of meanings the word or expression was used by the constitution makers. And in discharging the duty, the court will take into account the context in which it occurs, the object for which it was used, its collocation, the general congruity with the concept or object it was intended to articulate, and a host of other considerations. Above all, the court will avoid repugnancy with norms of justice and reason. The Supreme Court illuminatingly highlighted the above position in His Highness Madhav Rao Divaji Rao versus Union of India, 1971 Supreme Court 85. The concept is known as nocitore society. However rigid, the laws will be interpreted in a flexible manner so as to see that the rule of law is not abrogated and one is not made to suffer merely on a technical ground. It is true, as observed by Bourgeois in Richardson versus Muley, a public policy is an unruly, harsh, and dangerous to ride. The Honorable Supreme Court in Ratan Chand versus Askar Nawaz Jung, 1991-3 SC 67, pointed out that all courts have, at one time or other, failed to lead the bridge, failed to lead to bridge the gap between what is and what is intended to be, that the courts cannot in such circumstances shirk from their duty and refuse to fill the gap, that in performing this duty, they do not force upon the society their value judgments, that they respect and accept the prevailing values and what is expected of them, and that on the other hand, the court will fail in their duty if they do not rise to the occasion, but approve helplessly of an interpretation of a statute or a document or of an individual which is certain to subvert the social goal and endanger the public good. I think in a nutshell, this is what I wanted to tell you. Thank you. Thank you for giving me this opportunity to speak to you on a very interesting subject.
Thank you. Thank you, Justice Prasad, for delivering this lecture. In fact, we have a few questions that my students and I see Professor Krishnadev Singh Chauhan has also posted a question.
Can I ask a question to the judge?
Yes, please, sir. Please go ahead.
Well, first of all, I want to thank him for this fascinating lecture. I really appreciate the fact that he took so much time to, prepare a comprehensive text and also reflect on it. So one of the things that I wanted to ask you is that if we recall the SR Bommai judgment, the court used the terminology, something called manageable standards that we don't have judicially. Now, I was always struck by that, phraseology. And of course, many other judges and judgments have referred. Now, when you, when you are sitting sometimes together with you actually write a judgment, how actually manageable standards and connect that with your commitment to a statutory interpretation that is in line with both your philosophy and your ability to appreciate what the law on the matter is.
No, that is what exactly I said, because the court said that you must rise to the occasion. That was the first starting point which led to Bommai. And in fact, Bommai's case actually presented a very interesting this thing, because when we were hearing that governor's power matter, this thing, there this very same question arose. We were deliberating whether these same standards we can apply, because it is very easy to say that apply this law on a case-to-case basis. I said, later when in fact it was reported in the newspapers the next day, I said, you can do it on a case-to-case basis, but not on a suitcase-to-suitcase basis. You see, this manageable standard is something which is ethical. You see, manageable standards cannot mean what now it is being understood as that we manage the situation. You see, manageable standards must have some rule of law background for it, something ethical to it. Otherwise, looking at the scenario that is prevalent in the society today, we cannot mold ourselves to the managerial standards. Well, what was a manageable standard maybe 4 decades back may be not manageable today.
Thank you, sir. Thank you for that. Trupti, yeah, please carry on. Sorry, I interrupted.
No. It was...
Yes, sir. The next question that I would like to pose to you is a question from Professor Krishnadev Singh Chauhan. I am assisting him in teaching this subject. So the question is, in actual decision making, how feasible is it for judges to maintain complete objectivity, especially when language of law is ambiguous?
You see, that is what exactly I said.
Exactly.
That your philosophy may be coming in conflict with what the legislature says, but with that limited role of interpretation given to you, you cannot impose your personal views for an interpretation which is not clearly spelled out from the language used in the statute.
Absolutely, sir. So the next question is from a student of mine, and he says, do you agree with the idea of working on Herculean judge who keeps in mind all the previously decided cases and then decide the case in front of him? But as you said again, it cannot be from a suitcase to suitcase basis. Right.
No, I'll tell you. You see, as a matter of fact, you see, there are judges who rely mostly on precedents. And there are judges who hardly refer to precedents. And I have something, this thing, in a lighter vein, all it's in a lighter vein, I used to say that a new trend has come to judiciary now. You say that I entirely agree with my learned brother. I would like to add a few words. That few words run to 148 pages. You see, that is the answer when he said that volumes of...
Absolutely. So there's just another question, which is how and when do they deviate if they have to? Secondly, do you think judicial accountability plays a role in interpretation, especially when interpreting constitutional provisions and amendments?
You see, there is nothing called a judicial accountability. I always have felt that you are accountable to three in different stages. First, you are accountable to yourself, your conscience. Second, you are accountable to the society where you live, your country. Third, to the entire humanity. But I will say it's not in the descending order, it's in the ascending order. Your accountability should come first. You must say that, well, I believe this is the correct interpretation, and forget about my own ideologies, my perceived conceptions. And this is the way it should be interpreted so that it gives the maximum that can be given to the people at large.
Right, sir. Very insightful and very well said, sir. And so with this, I think we come to the end of all the question answers, and I'm really grateful that you agreed to deliver this lecture on behalf of Jindal Global Law School. And I'm very grateful to Professor Srijit, Professor Rajkumar for coming here and gracing the occasion. And with this, I would like to conclude the lecture. Thank you all for joining. It was wonderful.
And we look forward to welcoming you to our campus, sir, at the earliest opportunity. Thank you very much.
When physical distancing is taken out,
Yes.
I'll certainly come. Thank you, Rajkumar. Long time.
Yes, sir. It's so good. Thank you, sir.
Thank you. Thank you.
Bye, Tuti. Thanks.
Goodbye, sir.